everyone, to the third annual Generations in Arbitrations Conference, Hong Kong Legal Week edition. For those of you in the room who aren't very familiar with the Generations in Arbitration Conference, it is a conference that was actually started about 2 decades ago, starting in Vienna. It's connected to the Wismut competitions, which take place in both Vienna and Hong Kong, and has steadily grown over the years. We are proudly in our 18th year in Vienna. In Hong Kong, we are in our 14th year, I believe. And about 3 years ago, we kicked off the Hong Kong Legal Week edition, thanks to the kind invitation of the Hong Kong DOJ. And here we are today. So, what I would like to do first is to introduce you to our wonderful welcome note speaker. We're very excited and honored to have him with us today. Mr. Kwok Kon Horace Chung, SBS JP, who is our Deputy Secretary for Justice for the Government of Hong Kong, SAR. He will come up and give us some welcome notes. I'm sure all of you in this room know him well, so I won't give the brief bio, but his bio is available online. Mr. Chung, please come up here. Thank you very much.
Distinguished guests, ladies and gentlemen, good afternoon. It gives me great pleasure to welcome you all to the second day of the Hong Kong Legal Week 2022. The National 14th Five-Year Plan, a key national development strategy, supports the development of the 8 centers in Hong Kong, including to enhance its status as the international finance, transportation, and trade center, and center for international legal and dispute resolution services in the Asian Pacific region. As echoed in the policy address this year, the Hong Kong SAR government will continue to leverage on the advantages of our common law system to consolidate our strengths as an international legal services platform for deal-making and dispute resolution, and to enhance the efficiency and competitiveness of the legal sector. The conference today will discuss the latest development in arbitration and the application of the United Nations Convention on Contracts for International Sales of Goods, CISG, in Hong Kong, and how these new developments could further enhance Hong Kong's attractiveness as an ideal place for dispute resolution in the region and beyond. Under the one country, two systems, Hong Kong is the only common law jurisdiction in China. In the past 25 years since the return of Hong Kong to the motherland, Hong Kong and the mainland have entered into 9 arrangements on mutual legal assistance in civil and commercial matters, amongst which these 3 of the arrangements are arbitration-related, establishing effective mechanism to facilitate reciprocal recognition and mutual enforcement of arbitral awards, and interim measures for protection of property, evidence, and conduct preservation. Hong Kong possesses intrinsic strength in dispute resolution, with a pool of knowledgeable and experienced dispute resolution tenants specializing in areas such as commerce and finance, shipping, construction, and international investment law. We also have a sound and robust legal system, solid foundations of the rule of law, and our judiciary adopts a pro-arbitration approach in upholding the wide discretion of arbitrators and the neutrality and flexibility of the arbitral process. While our long-standing qualities earn us the laurel as the third most preferred seat for arbitration last year, as well as the top 5 preferred arbitral seats globally since 2015. It's only by our continued efforts in exploring innovative developments that could keep us competitive in the international arena of dispute resolution. Over the years, the arbitration ordinance has been refined from time to time to reflect the latest international arbitration developments and to provide an up-to-date and accommodating legislative framework for arbitration in Hong Kong. In 2017, amendments were made to the arbitration ordinance to clarify that third-party funding of arbitration and mediation is not prohibited by the common law doctrines of maintenance and charity and provides for related safeguards. The Code of Practice for Third-Party Funding of Arbitration, which sets out the practice and standard required of the third-party funders, was issued in December 2018, before the relevant provisions in the arbitration ordinance came into operation in February 2019. Over the past 3 years, we have observed a significant growing trend in the use of third-party funding in arbitration. The surge in the use of the regime by the arbitration sector has proven it to be a success, especially because it clarifies the legal position to facilitate arbitration parties lacking financial resources to pursue their claims with additional means, hence improving access to justice. This year, the government is pursuing another major breakthrough to further widen the spectrum for arbitration funding options. Earlier in June, legislative amendments were made for the arbitration ordinance, providing that certain agreements using outcome-related fee structure for arbitration, or OFSA in short, are not prohibited by the common law doctrines of maintenance, charity, and barratry. OFSA allows for greater autonomy for clients and lawyers to devise fee arrangements that suit their financial and business needs, assist parties in managing risks inherent in the arbitration process, and unlocks the funding options that lawyers could offer to their clients. Yesterday, members of the panel on legal matters of the Legislative Council were briefed on the OFSA subsidiary legislation. The panel support the papers. The subsidiary legislation will be introduced into the Legislative Council for legislative vetting, and is hopeful that the OFSA regime will be fully implemented in Hong Kong in December this year, thereby benefiting the arbitration users and legal sector, and enhancing Hong Kong's competitiveness by offering new funding options for Hong Kong's arbitration services. On the topic of dispute resolution, it would be incomplete without mentioning the development of online dispute resolution, ODR, in Hong Kong. As supported by the Chief Executive in his policy address this year, to enhance the efficiency and competitiveness of the legal sector, the government is committed to promoting the wider use of NORTAD. The Department of Justice will also strive to establish an online mediation platform in the Greater Bay Area next year to provide Hong Kong and mainland residents with time and cost-effective online option for resolving cross-border disputes. With the support of the DOJ, Hong Kong's homegrown service provider of ODR and related service, eBrain International Online Dispute Resolution Center, eBrain, has officially launched its online arbitration and online mediation platform just 2 weeks ago. eBrain plans to introduce an online deal-making platform towards the end of this year. These new platforms would not only enhance Hong Kong's NORTAD development capacity by offering flexible, secure, reliable, and affordable one-stop-shop online services, but also further strengthen Hong Kong's position as an international hub for legal, deal-making, and dispute resolution services. Another notable development in the legal field is the full implementation of the CISG in Hong Kong with effect from the first day of December this year. The relevant ordinance was passed by the Legislative Council in September last year, and it will come into operation on the same day to implement the convention locally. The CISG has been described as the most successful substantive uniform commercial law treaty. Currently, there are 95 contracting states to the CISG from different legal traditions and various levels of economic development, representing over 2/3 of the global economy. It's also remarkable to note that nearly half of the countries participating in the Belt and Road Initiative and more than half of Hong Kong's top 20 principal trading partners are also CISG contracting states. According to the statistics published by the United Nations Conference on Trade and Development, global trade reached a record high in 2021. As compared with the fourth quarter of 2019, East Asia has recorded the respective growth of 26% in import and 35% in export in the fourth quarter of 2021. Further, statistics published by the World Trade Organization shows that Hong Kong ranked the 6th in 2021 for the export of world merchandise trade and was the third largest exporter after the mainland and Japan in the region. Applying the CISG to Hong Kong could facilitate deal-making and reduce transaction costs as it announced for a uniform sale law to govern the bulk of Hong Kong business international sales transactions, enabling business to trade with their overseas counterparts on a fair and level playing field by using a sale law which are familiar to both. With increasing international trades, commercial disputes are unavoidable. Implementing the CISG in Hong Kong also creates new opportunities for Hong Kong's legal and dispute resolution professionals to advise and handle CISG-related disputes as legal advisors, advocates, and arbitrators, thereby widening the scope of their legal services, enhancing their competitiveness, and reinforcing Hong Kong's position as a leading center for international legal and dispute resolution services in terms of both arbitration and litigation. With the development of more cases on international trade law, the court, legal practitioners, arbitrators in Hong Kong could also contribute to the global development of international commercial trade law. The application and implementation of the CISG makes an important milestone for the development of international sale of goods law in Hong Kong. We are confident that Hong Kong and its overseas trading partners, including those along the Belt and Road Initiative, will benefit from this new development. As remarked by President Xi in the important speech delivered on the 1st of July this year, Hong Kong's close connection with the world market and strong support from the motherland remains its distinctive advantages. The latest development in the legal sector have created abundant opportunities for our aspiring legal professionals locally and internationally. It's one of our department's key policy initiative this year to continue to promote the strength of and opportunities for Hong Kong's legal and dispute resolution services on all fronts. Last but not least, I would like to express my thanks to the Mood Alumni Association and Winford Worldwide for putting together this wonderful program, and to our speakers for sharing their views highlighting Hong Kong's latest developments in arbitration and in CISG. May I wish you all a fruitful discussion this afternoon. Thank you very much.
Thank you very much. That was a wonderful start. Thank you very much, Mr. Chung. We are very delighted and honored again to have you here. We are also extremely delighted and honored to have two wonderful panels. I forgot to mention, this is a hybrid event, so we actually have a good number of people that are registered online. For my speakers, just look in the camera so that they could see that you're looking at them. I'm going to take this opportunity to invite panel number 1 to come up. I think they got a little bit of bad news. I think you got to keep the... Sorry. But please come up and join me on the stage. I think that means I need to now put it up. Does that match? We have a very colorful array today, I'm very proud to say. I'm going to just do the duty of introducing you to the moderator, who will then introduce the panel and the panel itself. But a quick summary, panel 1 basically is developments in the APAC region, why Asia remains an ideal place to resolve cross-border disputes. Ms. Margaret Wo, who is an associate at Withers Worldwide, is the moderator, and she will explain to you more about what the panel will discuss today. But as has been hinted at, and also as I'm sure everyone here is well aware, we are near the end, if not already there, of the pandemic. And yet, you know, there's still disputes to come. There are many developments that have happened over the last few years. Nothing really stopped. And so this panel is going to do a great job in giving you all of the wonderful information as to why APAC, in particular Hong Kong, still remains an ideal place to resolve disputes. Ms. Margaret Wo, as I was introducing, sorry I got a little distracted, she is an associate at Withers Worldwide and the moderator for today's panel. Margaret has extensive experience in international arbitration, commercial shipping, as well as corporate litigation and commercial litigation disputes. You can see her bio also online, so I'm not going to go into too much detail and make her even more red. Margaret, I'm going to hand over the panel to you. You've got the mic.
Hello. So I'm Margaret. I'm an associate with Withers, as Shirley was introducing earlier. So hello to everyone here. And for those of you joining online, please feel free to ask questions. Just put them in the chat box I believe it's using Zoom. And for those of you who are here in person, please hold your questions till the end of this session, but we will have a Q&A section, and I will try and make sure I see everyone past the very bright lights. So just very, very briefly, our section here is the third edition of the Generations in Arbitration Conference here for the Hong Kong Legal Week. And our topic specifically is focusing on developments in the APAC region and why Asia is still an ideal place for the resolution of cross-border disputes. So as Sherlyn was saying earlier, we are hopefully coming to the end of this whole entire COVID shenanigans. It has impacted us in many, many different ways. Obviously, personally, we have all been deeply affected by this. Professionally, and more relevantly to today's topic, it's also affected us in how we deal with legal proceedings and, for us, arbitration. There have been significant changes in arbitration in the APAC region as a result of the COVID pandemic, and so we will be discussing some of those today. In no specific order, I'm just going to go down our line here of panelists. So at the very far end, we have Mr. Wilfred Ho. He is counsel at Skadden on the team for international litigation and arbitration. He has a very broad commercial disputes practice, including restructuring insolvency, shareholder and JV disputes, joint venture disputes, and also in trusts as well. He has acted for a number of extremely high-value companies, both listed and private, in a variety of industries, energy, media, entertainment, travel, and has acted in a number of very high-profile, high-value arbitrations and complex cross-jurisdictional disputes. Next to Wilfred, we have Ms. Cheng Yi Kong. She is not only Senior Relationship Manager with Omni Bridgeway here in Asia, but she also leads the Hong Kong office for Omni Bridgeway. She also comes from a qualified background. She is qualified in both England and in Malaysia, and is a specialist in international arbitration and has worked in leading practices in Paris, London, and also in Kuala Lumpur. She also helped to found the Asia office of the ICC and served for 8 years as the director and counsel of the ICC, International Court of Arbitration Secretariat for Asia, and currently also serves on a number of committees and chambers of commerce in relation to arbitration. So she is very, very, very knowledgeable about this topic. Next to Cheng Yi, we have Mr. Thomas Walsh. He's a partner at Clifford Chance, and he co-leads Clifford Chance's Greater China International Arbitration Practice and also heads up the Korean disputes practice. He is admitted in Hong Kong, England, and also as a foreign legal consultant in Korea. And similar to Wilfred, he has a very, very, very broad range of disputes in on his CV. Specifically, a lot work in M&A, private equity, pharmaceuticals, pharma, aviation, and also in tech. And also has had a leading leadership roles in many leading arbitral institutions, HKIEC, ICC, KCAB. So he's been very, very involved in arbitration and is very, very well versed in a lot of the major rules, such as ICC, HKIEC, UN, CITRAL, CTAC, LCIA, and SIAC. And lastly, but not least, next to me, we have Ms. Venus Cheng. She is the Deputy Principal Government Counsel in the Legal Enhancement and Development Office of the DOJ. It's a very, very long title. So Venus and her team assist in implementing the DOJ policies for relating to legal and dispute resolution services. Particularly relevant, she also previously headed up the team that led to the recent legislative amendments which now allow the outcome-related fees for arbitrations in Hong Kong. And she has also worked on the development of mediation practice in Hong Kong. So although she is with the DOJ, she also has very, very solid knowledge about the policy side of things. So that wraps up my introductions for the panel and today's topic. So I think we can just jump straight into it, unless there's anything else anyone wants to add here. And just very, very broadly, we'll start with the question of what are the strengths of Asian dispute resolution centers that have made them attractive? Please go ahead. Yes, Cheng Yi, you can start. Am I supposed to keep? Yep, it's already on.
Hello. Yes, you can hear me. Thank you very much, Margaret. Thanks very much to the DOJ and for organizing Hong Kong Legal Week. I'm delighted to be here with all of you. So, yes, I can explain, perhaps, give a brief explanation as to why Omni Bridgeway set up its Asia offices. And to understand why we did this, I should perhaps provide a little bit of background to dispute finance or third-party funding, because Omni Bridgeway was one of the founders of modern-day dispute finance or third-party funding. So we've been providing litigation, finance, and asset recovery services since the 1980s. From Australia and the Netherlands. And you might ask yourself, these are rather random places to provide finance. And it's because we used to be two separate companies, IMF Bentham, which originated in Australia, an ASX-listed company, and Legacy Omni Bridgeway, which originated from the Netherlands. And some years ago, we merged and therefore became just Omni Bridgeway. And so dispute finance, really, for litigation has grown significantly since the 2000s in Australia, the US, and the UK. And the international arbitration community began focusing on dispute finance or third-party funding notably when the ICA Queen Mary University of London Task Force on Third-Party Funding was established in 2013 and comprised a diverse group of leading experts from arbitral institutions, states, academics, and a range of third-party funders. And in 2015, the Law Reform Commission in Hong Kong released a report recommending that the law should be amended to expressly permit third-party funding of arbitration and associated proceedings under the Arbitration Ordinance. And shortly afterwards, in 2016 and 2017, Omni Bridgeway funded a number of insolvency-related cases in Hong Kong, all of which were successfully settled in our client's favour. And some of you in the audience may be aware that, in fact, since 2007, the Hong Kong courts have consistently confirmed the availability of third-party funding in insolvencies. And the Singapore courts followed suit in 2015. And we continue to fund insolvency-related cases before the Hong Kong and Singapore courts. So Omni Bridgeway officially launched its first Asia office in Singapore in 2017, the same year that Singapore amended its Civil Law Act to abolish the torts of maintenance and champati and passed regulations to expressly facilitate the funding of arbitration, mediation, and associated proceedings. And then similar legislative changes were made to the Arbitration Ordinance in 2017, which came into effect in early 2019, together with a code of practice for funders. And so in line with those legislative changes, we established the Hong Kong office in early 2018. And so why are these two city-states obvious choices for international funders to establish offices in Asia? And so the answer lies in the fact that investment favours transparency and certainty, political stability, robust and independent court systems that are sophisticated and arbitration-friendly, as well as an abundance of international law firms, presence of major arbitral institutions and renowned international arbitrators, all of which Hong Kong has in abundance. And the accessibility of both jurisdictions is also a key factor. So I think after some years of turbulence, I think Hong Kong is rightly focusing on its efforts to regain its mojo, if I can say that, and also demonstrating its resilience. So since launching our Asia operations, we have received around 500 applications for funding originating from Asia, and I think the majority of which involve arbitrations. And so that, in my view, that's a pretty good indication that Asia remains an ideal place to resolve disputes. Thanks.
I guess I'll go next. So in terms of the question, I thought about it a little bit, and I thought that it might be actually interesting to look at it from a slightly different perspective. And I think Deputy Secretary of Justice just talked about trade patterns. I think actually, I'm a great believer of if you build it, they'll come. But I actually do think that, there are some kind of fundamental conditions that are important for arbitration centres and also dispute resolution centres to thrive. And of course, one of them is trade. And in the last 50 years, there's obviously been a huge sea change in the kind of trade patterns that we've seen. So one of them is, for example, South-South trade. So in 1960, for example, only 24% of developing countries' exports were directed to each other. In 2001, that became 40%. And now it's 52% of all South-South economies' exports in 2018. And, these patterns, trade patterns, are not reflected just in trade of goods. We can see that in the share of developing economies in the world commercial services exports. In 2000, that was only 25%. And it's now 31%, of which China, India, Singapore, Hong Kong, and Republic of Korea accounts for half of the southern economy's services exports. Southern economies, as a source of foreign direct investment, has also increased. And they now constitute 1/3 of global outward FDI, which is an increase from 10% of global outward FDI in 2000. So, why are these trade patterns important for the growth of Asian dispute resolution centres? Well, first of all, as I just said, you've got the economic conditions. there's trade happening, and the flows have changed. It's no longer south-north, north-south. It's south-south and south-north. And so, it may very well be that the trade drives development of arbitration. Obviously, it's important to capture that, the trade or disputes about trade with world-class arbitration centers. And, that's, I think, something that Asia is very good at. Obviously, there's varying levels of development in Asia. Singapore still likes to call itself a developing country. But, for example, 38 jurisdictions in Asia Pacific has adopted the model law on international commercial arbitration, this UNCITRAL model law. Hong Kong is obviously a model law jurisdiction. Singapore based its arbitration law on the model law. And even the UAE in 2018 adopted a new federal law that is based on the UNCITRAL model law. So, we've also got greater developments. For example, there's the proposed amendments in the PRC law. So, that hasn't come yet into force, but a consultation paper was issued last year where there'll be recognized seat of arbitration, allowing foreign arbitral institutions to conduct foreign-related arbitration business, recognition of ad hoc arbitration, recognition of competence doctrine. So we are seeing steps taken in the PRC to move the PRC arbitration law to be harmonized with the rest of the international community. India's also making significant strides, although, on certain matters, they aren't consonant with the rest of the world yet. In ASEAN, the Asian International Arbitration Center published its 2021 arbitration rules. Thailand did the same thing, and Cambodia also had new arbitration rules, which included new expedited procedure and provisions for appointment of emergency arbitrators. So I think we are seeing that development. We're seeing the trade patterns, and we are also seeing, Asian jurisdictions step up their game in terms of having world-class, state-of-the-art arbitration frameworks. So, in my view, I think those two things are the things that strengthen Asia's kind of claim to be at the forefront of dispute resolution, especially arbitration.
Thank you, Wilfred. That was actually very illuminating. And also thank you, Cheng Yi, earlier for your explanation about why Omni Bridgeway ended up setting up in Asia, because of the strengths that you mentioned earlier. So maybe if we can just change tact a little bit right now, and maybe, Venus, you can give us a little bit more of guidance or some explanation on maybe the practical side of why Hong Kong and why Asia in general is quite strong for DR.
Thank you, Margaret. I think given my position, it wouldn't be convincing if I start talking about other jurisdictions in the first place. So I think some of the strength that Hong Kong has as a dispute resolution center, I think, was mentioned by DSJ in his speech earlier. But I would like to reiterate some of the points, our unique features of Hong Kong's, that why makes Hong Kong irresistibly attractive seat for arbitration. Under the principle of one country, two system, Hong Kong enjoys a high degree of autonomy. It is the only common law jurisdiction within China. It has our mature and independent judiciary. It's guaranteed under the basic law and ensures that the exercise of judicial power should be free from interference. We also currently have 10 non-permanent judges of foreign nationalities in our Court of Final Appeal. And the judgments have been of the highest qualities and regularly cited in other jurisdictions. Both the English and Chinese are our official languages. We have bilingual legislations, and cases can be conducted in Chinese and English as well. Besides that, we have a very diverse pool of talents. We are rich in our culture. We are the gateway to China, to mainland China. And my figures might be a bit outdated, but as at early this year, we have about 11,000 practicing solicitors in Hong Kong. We have 1,600 practicing barristers and 1,500 registered foreign lawyers from 33 jurisdictions and over 80 registered foreign law firms in Hong Kong. I think this is just a very general overview of why Hong Kong is one of the leading international dispute resolution center in Asia. And I think despite the pandemic and difficulties, around the world, I think Hong Kong, as our CEO said, Hong Kong is back, and we are, growing resilient and tenacious to meeting challenges.
Thank you, Venus. Okay, maybe looking at this from more of the practitioner's perspective, maybe Tom, you could chip in a little bit here. Some kind of practical advantages for Asia, Hong Kong.
Yeah. No. Does that work? Okay, yes. Sorry, normally my voice is loud enough that I don't need it. So look, I think the practical advantages are, one of the key things is actually you have the full legal community here. So I think really the fundamentals which have grown it are exactly as they said. This is the economic shift east, and also we have sensible institutions. HKSC was one of the first, and then we've had SEAC, and now we're seeing it with the JCAA and the KCAB. So basically you've got economic power going east, and then you have sensible institutions so people feel safe. But from a practitioner's perspective, the other thing we've seen is this development of some expats coming like me, but also local talent. So in Asia over the past 10, 20 years, you've seen this growth of people who natively do international dispute resolution. And that means it comes into a kind of virtuous circle of a system. So, for instance, in my team, I have people who started as trainees and are now counsel or partners, and they've spent their entire life in Asia-Pacific doing Asia-Pacific related disputes, natively speaking international arbitration, natively speaking cross-border litigation. And it's just going to be this continuous virtuous circle. And the other point, as we all know, and despite being the only white guy on the panel, is that a lot of these disputes are not in English anymore. They're English and Chinese, they're just Chinese, they're Japanese. Or the documents, even if the dispute's in English, you need to be able to understand these documents. And what everyone, bar me, really realizes is to really be able to do these disputes properly, you need to speak the languages. You need to understand them. You need to get the nuance. You need to get the cultural sensitivities. You need to be able to speak to the client. And it's something quite unique to Asia. You know, even when you have, say, a Chinese ethnicity lawyer in London, often the level of the Chinese is not quite the same or not specific enough to be able to speak legal Chinese, business Chinese. And I think it's just a self-fulfilling growth story which is going to happen in Asia, that more and more people are doing this from cradle to grave, and it's just going to keep growing, this pool of talented practitioners.
Fantastic, thank you. I'm going to try and open one more question in this kind of topic area about the strengths of Asia dispute resolution, is maybe just open the floor to everyone and just comparison of like what your experiences have been in handling of the disputes, arbitration and litigation both, between the various Asian centers. Especially for Wilfred and Tom, I believe both of you have done a lot of cross-jurisdictional work. And I think also Cheng Yi as well, you would be able to speak to maybe some, from the funder side at least, from the Omni Bridgeway side of things. How does this work cross-jurisdictionally? Just any comments on comparisons between, say, Hong Kong, Singapore, Japan, Korea?
Yeah, I mean, maybe if I can go first. I think the big elephant in the room is always Hong Kong and Singapore. There's a lot of it in the press recently, a lot of it with the FinTech Week recently, a lot of it with the HKMA conference recently. And, I mean, that's also, infiltrates the arbitration dispute resolution world. I think, there's probably more that's made about the differences or the competition than actually exists. I think it's Giorgio said on the SCMP recently that they're complementary centers, twin engines. There's a lot of, empathy for people of both of the cities for each other. So I think sometimes the competition is kind of, amped up and, it makes for good news sometimes. But, in my view, I think obviously the emphasis of the different centers, the emphasis of the centers are different. Hong Kong obviously has the advantage of being the direct bridge to the mainland. It's got the fourth largest capital market in the world. Apparently Hong Kong made up 60% of 211 billion deposits in all offshore markets last year. That was a statistic from the HKMA conference, according to Credit Agricole, so it must be correct. But you can see that it's more about capital, asset investment, especially with respect to China. Singapore, again, has a different emphasis. It's the commodity, one of the premier commodities trading hubs in the world. It's got energy, it's got investment, petroleum products, pharmaceuticals. It's part of ASEAN Free Trade Area, which Hong Kong is not. So, this kind of the flavor of the disputes in both of those jurisdictions are different. And I think, as you pass that out between the kind of two centers, which are very keen on doing arbitration, then you have other countries like Japan, you have, China, you have Korea, and in each of, for example, in East Asia and Southeast Asia, and also in South Asia, there are differences. For example, firstly, civil law, common law distinction, the way evidence is taken. In China, for example, there's a cultural sensitivity, which, to be honest, is, I think, not the same, but, similar in different varying forms throughout East Asia. Ideas of consensus building, ideas of, disputes not being, arbitration being helpful because it's not just about, being antagonistic or adversarial, right? So that's why arbitration and mediation appeals to East Asia. You have that in Southeast Asia too, and South Asia, just in different varying forms. So, I think the key thing is, there's a huge amount of variation in all the Asian, regions. I think cultural sensitivity is obviously very important. Hong Kong has the advantage of being part of China and therefore having direct access to the mainland. Singapore, different. It's situated geographically in Southeast Asia. It's part of ASEAN. And also, it's the choice of seat for most Indian parties outside India. So, for me, that's kind of the way that the flavors kind of work.
Anything you want to add to that, Tom?
No, look, I think the general approach now is most arbitration practitioners in Asia are fairly agnostic about the seat. I mean, we honestly don't care whether it's Hong Kong HKIC or Singapore SIAC. It's fine. Both work. But what I think is quite nice is both institutions being very good and having great secretariats and having great support from their governments are each pushing each other along. And actually what you're seeing is HKIC and SIAC leading other institutions globally. For instance, SIAC has, Singapore government has really dumped a lot of money into supporting SIAC, and there's been fast legislative amendments. Now you're seeing Hong Kong also doing the same. And I think actually it should be that both keep riffing off each other in that way. Look, we've got ICA in, I think, 2 years. That's going to be in Hong Kong. It's going to be a really big event. That's going to be firmly supported by the DOJ and others. And I think all of these kind of give a demonstration that Hong Kong and Singapore can kind of keep both competing with each other in a way which works for each other and actually for all of us. Because I'd far rather do my disputes here than, well, actually I quite like flying to Paris. But flying to Paris or flying to London, it's nice for Asian parties to do disputes in Asia.
Excellent. All right, I'm going to wrap up this section on strengths and maybe move on to our topics as I think we're running out on time. So maybe let's start discussing about what kind of trends and patterns or developments, being the main core topic here, have been seen in recent years that have helped to push Asia and in particular Hong Kong to the forefront as an international dispute resolution center. So maybe if I could get Wilfred and Tom to maybe kick this part of the discussion off again.
Yeah, I'm afraid you're going to be hearing a lot from me. And I'm going to be the trade guy, I think, for this panel. I think in terms of, we've said before about trade patterns. I mean, one of the key kind of, big changes, it's all in the media, is about how China has risen as an economic power. And if you look at, the kind of trade statistics, right, China became the lead trade partner to all the BRICS members, except the Russian Federation in 2009. India, for example, is projected to become the second largest economy in 2050. China in 2020 was the top trading partner to 128 out of 190 countries, and that includes the United States. ASEAN became China's leading largest trading partner in 2020. China was the largest trade partner with India in 2021 and 2022. So, I mean, I can rail off these statistics, but we are seeing trade flows moving, and it's not just a story of triumphalism. I think you have to be very, very careful what these trade patterns mean. There's still an issue about South-South trade having, in terms of adding value, right, to global value chains, right? So, there's all that old story that was about a decade ago that, a $150 iPhone, only $4 is attributed to China. So it's not just a story about triumphalism. It's more about that trade flows are changing. How can, Asian dispute resolution centers capitalize on it? The good thing is we are seeing trade flows, right? I mean, the trade statistics for Africa and Latin America are very, very different. So, I think from my perspective, there's a lot of helpful things in terms of economics, in terms of trade. And the question for us, I think, in Hong Kong and also in Singapore is how do we capitalize on it? And I think, the unique advantage, obviously, with Hong Kong is that it is part of China. It has the mutual arrangements, which I think Venus is going to talk about. But it has that direct kind of bridge to the mainland and that advantage.
Tom?
Yeah, so I think one of the things the arbitration industry does is you come up with a pledge, a catchphrase, a trend, and you hitch your cart to it, and then everyone talks about it a lot. But I think, ironically, it really is the fundamental that Wilfred's talking about. Outcome-related fee structures, that's great. And once there's a dispute, people will use it. But really what the trend which has made the difference is Asia getting wealthier and big companies being based here, big companies having confidence in the jurisdiction and saying, let's go there. So I think the fundamental thing is to keep investing in the hubs or the mid-grounds which enable these disputes to take place. The Hong Kong government has long supported the HKIC in Hong Kong as a seat. If it keeps doing that, effectively pumping money into these institutions, making sure they're super efficient, making sure they've got great secretariats, making sure things are dealt with promptly, and that's the way it is now. You keep doing that, people use it and then come back. And Singapore's the same. Singapore has had an astounding rate of success and growth in international confidence, and that's because the government has put significant money and investment in, and people have experienced it and think, okay, I don't need to go to ICDR or AAA in New York. And that's what we need to keep doing. The fundamentals are there, but you've got to keep investing to build those kind of repeat customers, that repeat confidence.
Fantastic. So I think, Wilfred, earlier you had mentioned something about how PRC and there's arrangements with China. Venus, as our local policy specialist, maybe you could give us some insight into this.
Yes, thank you, Margaret, and thank you, Tom and Wilfred, for talking about the mutual legal assistance arrangement and also about the legislative changes we have in Hong Kong. Since the return of Hong Kong to motherland 25 years ago, Hong Kong have already entered into 9 mutual legal assisted arrangement with China in civil and commercial matters, amongst which 3 of the arrangements are arbitration related, and it actually establishes an effective mechanism to facilitate reciprocal recognition and mutual enforcement of arbitral awards and interim measures for protection of property, evidence, and conduct preservations. And I'm not going to go into details of each of the arrangements, but generally it actually facilitates parties consider choosing Hong Kong as a seat of arbitration, and it actually do have access to mainland China. And another development we have in relation to the arrangement is the recent REJ arrangement the legislation has just been passed recently in the Legislative Council. And the effective date is to be further considered with mainland counterparts. But this is another breakthrough we have in Hong Kong. And besides that, on funding options, the DSJ just mentioned earlier about the third-party funding arrangement we have in Hong Kong. And even earlier on in 2017, we actually amended the arbitration ordinance to clarify that intellectual property rights can be arbitrated in Hong Kong. And before I go into the outcome-related fee structures for arbitration, I would really like to take this opportunity to thank members of the advisory body, Catherine, Benny, and Brianna. I'm sure they're watching this online, for the tireless efforts in going through details, each and every comments we have received from the practitioners and stakeholders. The end product, which was mentioned by DSJ earlier, that we've actually briefed the AJL's panel yesterday, and they were generally supported by the Law Society and the Bar Association, and of course by the legislative members as well. I wish to mention at the outset that every piece of legislation is truly a collective effort of the legal community, and it's not just the DOJ. And in the context of promotion of arbitration, I think at the heart of what we do at DOJ, we strive to refine the legislative framework for the benefits of the legal community and potential users of arbitration services in Hong Kong. And with the introduction, let me just generally give an overview of the outcome-related fee structures for arbitration. In short, we call it OFSA. the amendments to the arbitration ordinance, which is the new Part 10B, was gazetted on the 30th of June this year. The operative provisions, which is the Division 3, 4, and 7, will come into operation on a date to be appointed, and it is, well, I guess I can say that it's going to be on the 16th of December 2022. And it will be operative together with the subsidiary legislation, which sets up the safeguards for the officer regime. And the officer regime actually was based on the Law Reform Commission report published on the 15th December last year. And it was recommended that there would be 3 types of officer arrangement be allowed, namely the conditional fee agreement, which is the CFA, damages-based agreement, which is the DBA, and a hybrid damages-based agreement, which is a hybrid DBA. So very quickly, a CFA is actually an agreement between a lawyer and a client, and the agreement to be paid a success fee, which is an additional fee to be paid only in the event of a successful outcome for the client in the matter. And the DBA is agreement where the lawyer's fee is calculated by reference to the financial benefit that is obtained in respect of the outcome of the claim or proceeding that the client agrees to pay the lawyer. So that's the DBA payment. And a hybrid DBA is an agreement where the lawyer charges a fee for the legal services, usually at the discounted rate, plus in the event that the client obtains a financial benefit in the matter, which is a DBA payment. And in this 3 arrangement, I mean, for the DBA and the hybrid DBA is actually quite a breakthrough for Hong Kong because we are actually one step ahead comparing to Singapore, which only allows for a CFA. And this, the reason why the Law Reform Commission actually proposed these 3 types of arrangement is actually through extensive consultation with the stakeholders, and there are actually demands for a wider scope of funding options in Hong Kong, in addition to third-party funding, which actually is allowed. And clients actually wanted to have a more flexible fee arrangements and for the lawyers to share the risks in the arbitration. And this is also to keep up with international practices because around the world, most major arbitral seats actually have some sort of funding arrangement similar to either CFA or in UK, they also have similar arrangement as well. So all these are actually some steps that Hong Kong's taken, especially DOJ, to actually provide such an environment for the legal community and for the clients to consider choosing Hong Kong as one of the seats. And of course, and also mentioned by DSJ earlier, which will be covered in panel 2, the CISG is also another development in Hong Kong, providing a legislative framework for Hong Kong as well. And just jumping a bit outside of legislative framework, the DOJ also have been enhancing and promoting the use of law tag. In 2018, we actually facilitated eBram to set up in Hong Kong to provide online dispute resolution services. And since then, they have a lot of developments, for example, launching the first COVID-19 ODR scheme. That is actually also to there was also demand from stakeholders, whether they could actually have some sort of an online mechanism to resolve their disputes because of the pandemic, where it's not so conducive to meeting physically in person. And also this year, the more major development, the eBram actually launched the legal cloud portal for practitioners, so they can actually make use of the cloud services. And in May this year, it actually launched the APAC ODR rules and online platform. So APAC dispute can use eBram services to resolve their disputes. And in just recently, last month, they actually launched an online arbitration and online mediation platform to facilitate parties to use their services to resolve their disputes. And these are actually tremendous development within a really short time. And It is also in our DOJ's policy initiative to actually further promote the use of law tech, especially in the GBA. And the DOJ will be setting up a GBA task force to actually look into how we could actually facilitate the further use of ODR within the GBA to resolve disputes, cross-boundary dispute in particular.
Okay, thank you, Venus. I'm just going to jump backwards a little bit. You had mentioned about the outcome-related fees arrangements earlier, and so I'm just going to go back to Cheng Yi a little bit and just maybe discuss some shifts that you may or may not have seen in relation to the attitudes towards funding, because Hong Kong has traditionally been very anti-contingency of fee arrangements, champerty, maintenance, all those rules. So have you seen any kind of changes, any shifts, positive, negative, and also maybe just changes seen overall in arbitrations, restructuring, and solvency disputes?
Thanks a lot, Margaret. Basically, as a funder, I think we're incredibly grateful to the sort of friendly rivalry between Hong Kong and Singapore. It's really made it so easy for us to set up shop in both jurisdictions, and I think third-party funding in Asia is doing well, mainly because of the benefits offered by both jurisdictions, making the laws very clear as to when and in what circumstances funders can fund cases. So in terms of trends, what we've seen in Asia is that funding applications, and this is not just Asia actually, it's more global, funding applications used to originate mainly from impecunious parties who have good claims but who can't afford the legal costs of bringing those claims. But increasingly, especially the last 5 years or so, we've seen applications, more and more applications, coming from well-resourced companies, entrepreneurs, and even state-owned entities who are seeking to manage the financial risk of litigating. And what do I mean by financial risk? Well, that's basically to do with the non-recourse nature of funding. Funders finance all or part of the legal and other costs, and they receive nothing in return, and they don't even receive a reimbursement of what they funded if the parties that they fund lose the case, or even if they win the case, but they fail to obtain recoveries from the losing party. So the nature of litigation finance is actually quite different from an insurance policy, where a premium is always payable, or from a bank loan, which must always be reimbursed with interest. So basically, our clients get complete downside protection in exchange for giving up a slice of the financial upside if they win and if we manage to get recoveries for them. And in terms of Omni Bridgeway, not only do we, if our clients lose, not only do we not get any reimbursement of the costs we funded, we also remain on the hook for adverse costs because we provide cover to our clients for security of costs and adverse costs orders. And perhaps another reason why we see more and more conglomerates turning to litigation finance is to manage the enforcement risk. Winning a case and being awarded, damages isn't any good unless you can monetize it. And some years ago, so as I mentioned earlier, we merged with a specialist asset tracing and enforcement recovery funder. So now we offer asset tracing and enforcement services in-house. And we start looking at that right from the get-go. It forms part of our preliminary due diligence, and we maintain and refresh that sort of assessing the enforcement risks throughout the lifetime of a case. And sometimes the information we provide can be really important in terms of fine-tuning our clients' case strategies together with the lawyers. And sometimes it can even encourage the opposing parties to settle. I'll perhaps talk about the outcome-related fee structures in the next section.
Perfect. Thanks. Thank you so much, Cheng Yi. All right, so let's move this conversation along to, and I think Venus already started in on this a little bit with what are some developments that will make, so looking towards the future, what are some developments that are going to make Asia and or Hong Kong even more attractive as a dispute resolution for anything that comes in the future? And so Venus had already discussed, there are a bunch of policies that are going to be implemented, including the implementation already of the outcome-related fee structures for arbitration, ORFSA, and also the GBA and mutual legal assistance programs between there. But also, I think maybe, Cheng Yi, since you were just the last one to speak, we can go back and maybe just look at, at least from the funder's perspective right now, what is the impact of ORFSA since implementation, if any, and also going forwards?
Thanks, Margaret. So from a funder's perspective, we are very much in favor of the fact that arbitration lawyers in Singapore and shortly in Hong Kong will be able to offer, outcome-related fee structures for their clients. So in Singapore, as most of you probably know, lawyers are only permitted to offer conditional fee arrangements. But in Hong Kong, as Venus mentioned earlier, lawyers will be permitted to offer a much wider range of options. So conditional fee arrangements, damages-based agreements, and also hybrid damages-based agreements. And for us, this provides comfort that lawyers will have a genuine belief in the merits of their claim because they are willing to take on some financial risk. And it also offers a further opportunity for the parties, for their lawyers, and for funders to work closely together and fully align their interests. And it permits funders to take on smaller cases that might otherwise be difficult to fund without the lawyers taking on some risk. And it therefore helps also to facilitate access to justice for meritorious claims. Another potentially major development is that these structures introduce an additional option for funders to fund law firms, something that we've been doing for many years in the US. So basically what could happen is that the funder steps in behind the law firm, and then the law firm can take matters on risk, and the funding helps to defray the firm's overheads, pay salaries, and other out-of-pocket expenses. Clients need not even be aware that their lawyers are being funded. And it makes good commercial sense for the firm to be part-funded and then say 30 to 50% of their fees plus disbursements and other insurances to be covered by the funder, and then they can share the success fee with the funder.
Great, thank you. So I'm just going to change our focus a little bit now and going back to our trade guy, Wilfred over here. So Venus had earlier mentioned that CISG is going to be one of the developments in Hong Kong at the implementation of it. And I know that that's going to be our next panel as well, but I think that in this topic, since we're looking at developments, I think it's relevant that we have to talk about this. So from trade perspective, what do you think? How is the implementation of the CISG in Hong Kong going to impact the trade and commerce patterns that you had discussed earlier?
Yeah, so actually, one of the first cases I ever worked on in Hong Kong was a CISG dispute, and it had to do with silicon wafers. And the parties obviously chose to put in their applicable law clause in the Chinese phrase, or what we call governing law, and common law, to apply CISG if there is any doubt, Hong Kong law. So this was something about 2010, 2011, and so people are already using CISG. I think that because I think the key point of the implementation of CISG now is to make it automatic in relation to international contracts. I think that's fantastic. I mean, harmonization of laws, for me, it's in itself a virtue. I mean, I'm from, studied in two jurisdictions, Australia and the US, where they're both signatories to the CISG, although the Australian attitude to CISG is a little bit strange. And I hope that doesn't happen in Hong Kong, but I think it's fantastic. I actually think that, for me, the next question really should be is, CISG is really important. We've talked about the trade patterns, that's in goods. But Hong Kong is actually a services center. I mean, we're one of the most services-oriented economies in the entire world. We're like 93% services. And so the next step, really, I think, for us is, after CISG, is liberalization in services. I mean, where do we go from there? And, obviously, the chief executive talked about the regional comprehensive economic partnership. And that has, for example, liberalization in services. But, I think CISG is obviously helpful for the legal services market in Hong Kong because that allows, legal services, right? It will attract more legal services in relation to sale of goods, especially with China being already a signatory. But, for me, what's the next step? And, for me, that's services.
That's good to know. I'm just going to open this up to everyone now. Are there any other predictions you have for the continued development of dispute resolution in Hong Kong, taking into consideration all of the proposed initiatives that Venus has briefly outlined for us earlier? Maybe Tom, since we haven't heard from you in a while.
Yep, as long as you weren't going to ask me about CISG. As I think in 15 to 20 years of practicing, I've never had a case with it. Yeah. With great relief that it's not about CISG, what about all these developments? What's going to help Hong Kong? I think there's just two really simple ones. One, keep Hong Kong a safe place to do disputes. I think that comes from continued investment. I heard a lot about EBRAM, but I think really what do we focus on when we talk about arbitration? It's two things. Your leading institution, HKIC, we need to keep funding and supporting that, and it's the courts. Those are the things which really matter for regional dispute resolution. So keep Hong Kong a safe seat and fund those two things. Let's have electronic filing in courts. Let's have a specialized arbitration list. Let's make that as efficient as one can be. So one, make it a safe place for a seat, or it already is, but continue that investment. Keep competing with Singapore. Keep doing this. And the second is keep up these great developments on enforcement. As we've heard, there have been some amazing developments on enforcement, and it really means that Hong Kong has accelerated even what was a lead in being a sensible hub place for China. That can continue, that can develop, and it can also go wider within ASEAN. So I think invest in the seat and keep up these kind of enforcement-related developments, because really when people do a dispute, as Cheng Yi was saying, what they really actually care about is the enforcement.
Great. Cheng Yi, did you have anything else to add to what Tom's just saying?
Well, maybe not quite a prediction as a wish.
That works too.
Yeah. So, third-party funding, litigation finance, dispute finance, whatever you call it, it's very established in some jurisdictions, in the UK, Australia, the US, it's almost second nature. Whereas I know that Asia is a little bit behind, so it's only really taken up in the last 5 years or so. But I would love it if we were to perhaps continue beating the drum. I mean, the funders do try and beat the drum, but I think our voice is not loud enough. So if perhaps the government or someone could perhaps assist us to explain the benefits of litigation finance to corporates. Because I find frequently in these conferences we're preaching to the converted. The hard thing is to make or to explain to corporates what are the benefits of, from my very selfish point of view, dispute finance, but also, the law firms benefit from that, right? Because it allows them to take on perhaps cases that would be difficult to take on a single case basis, or even defense. You take on defenses, pure defenses, which funders can do. So, yeah, if perhaps some effort could be made towards explaining, demystifying perhaps litigation finance for corporates, that would be much appreciated.
So maybe that's a good point to lead in and ask Venus, will there be any kind of initiatives to try and introduce the litigation financing?
I think I can really add to Cheng Yi's point. Actually, it's in our policy initiative to actually do more, give more support to the legal and dispute resolution sector. We're actually besides developing law tech, we're actually thinking of doing more, providing practical tools or guidance to users of arbitrations across all sectors. So, for example, if you're talking about financing, litigation financing, we might actually, we can discuss more about what we can do for the sector, especially when we're promoting funding options for arbitration, be it third-party funding on OFSA. And also, I think, as Tom also mentioned, put more resources from the government, in the institution and judiciary. But I think I think maintaining Hong Kong's leading status as an international legal and dispute resolution center is not something that the government can do alone. Of course, the government will be one of the major players in this, but it also requires our legal professionals like you guys, dispute resolution practitioners. They have to be willing to learn, be open to new opportunities, be hungry for new developments, to stay ahead, even if it means disruption to existing practice like law tech. I mean, in the early days, people are not used to no face-to-face meetings, using Zoom, and they need fundings to have this equipment for video conferencing, and the government came in with the law tech fund, particularly for SME, noting that they may have this additional cost for their businesses. And I think it also, of course, requires continued efforts from the legal professional bodies to devote resources to nurture and inspire young generations. They are the ones who will join the legal profession in the future. And I think after all, it's a collective effort, and I think you probably would agree. The government alone, there's only so much we can do. We could provide a conducive environment, safe environment for arbitration in Hong Kong, but I think we are all in this as part of the legal community.
Fantastic. Thank you so much. Before I move this on to the Q&A section, I have been reminded to shamelessly plug our firm because that's part of my job. So I am with the dispute resolution team at Withers. I do have a very colorful arbitration and litigation background, but my team is led by the lovely Miss Sherlyn, who was doing the introductions earlier. And our arbitration team specifically, she's giving me a face right now, but she is fantastic. She's excellent to work with, very knowledgeable about all things arbitration. And yes, please do come and speak to us if you do have any other questions that you don't want to raise your hand to ask. But since we're at that point now, if you do have any questions for any of our panelists, but not me, please do raise your hand, and I will try and spot you with these lights. Yes, please. Sure.
So I have a question regarding the Hong Kong ASEAN Free Trade Agreement, which entered into force last year. It was one of the highlights of the Hong Kong efforts to place itself as a dispute as a center for the Belt and Road Initiative. So far, how effective has been this agreement related to trade and investment disputes regarding Hong Kong parties and parties in the ASEAN? Thank you.
I assume it's that directed to me as the trade guy.
Trade guy have to answer this.
Yes.
I mean, I actually haven't seen that many disputes. I mean, I can only deal with it from a disputes perspective. But I actually haven't seen that many disputes utilizing the clauses in the Hong Kong ASEAN FTA. But, I think, in my view, the more kind of, trade agreements there are, kind of the better, just because, we're seeing those trade flows change, and, that's kind of important.
Hello, hi. I'm Frank from China Merchant, and I have two questions. One is indeed the commodity trading and dispute. And we know in past years, I think the Hong Kong government has been working very hard to promote Hong Kong as a maritime hub of the region. But it looks like Hong Kong is not as attractive as Singapore to those commodity traders. And so regarding to that, Asia remains the ideal place to resolve cross-boundary disputes, and so comparison with Singapore, then what exactly the local legal community can do or further promote so as to make Hong Kong be more attractive to those commodities traders and make them coming back or open new offices in Hong Kong? Is the first question. Thank you.
I think this goes to Wilfred again.
Yeah, I mean, I think I saw recently that if you look at maritime disputes, for example, like if you look at the LMAA, the LMA still has the lion's share of, maritime disputes, something like 60 to 70%. I think Singapore's next and then Hong Kong, right? I mean, I think Tom will have the same experience. But trying to get parties to agree a seat is kind of, I don't know, putting your finger to the wind a little bit. I mean, there's a lot of factors involved, some of which are knee-jerk, some of which are not. I mean, one of the things is, I mean, at least in my practice, what I've seen a lot is, you know, Chinese parties actually have been very good in trying to utilize Hong Kong as, you know, a dispute resolution forum. So it's kind of interesting because, you know, I'm at a US firm and we get like calls from our Florida office about, you know, a interior designer from Hong Kong wanting to use HKIC, you know, as a dispute resolution forum. And we're like, how did you get, and it's like building a real, you know, a development in Florida. So we're like, how did you get this request? But it's just strange, you know, you do get I mean, if you have one side insisting on it, you know, I think that's how you would bring more of it. I think familiarity, obviously. So, you know, I think that's important, but neutrality is also really important. And, you know, I think that's also tied up with, you know, the current sort of, you know, what's in the media as well. So it's kind of, there's a lot of angles going on. I think you just have to, you know, try to, you know, persuade people on the ones you can. So, I think with, you know, if just on, let's say, commodities and maritime, I mean, it's going to be very hard to shake LMA's control of, you know, the maritime dispute. First of all, you know, shipping law has always been, you know, LMA, English thing, you know, it's just going to, you know, that's where the center is. But I mean, you know, for example, like, you know, shareholder disputes or securities disputes, I mean, Hong Kong's got an edge there. So I think it's kind of, I mean, it probably doesn't do very much for, you know, your organization, but, you know, there are definitely areas where Hong Kong has an advantage, and it's about kind of working. I mean, with commodities, I mean, it's going to be difficult. Singapore is the premier commodities trading hub for petroleum, for oil, for gas. I mean, it's, you know, that's not really Hong Kong's strength.
And thank you, and particularly thanks telling truth, yeah, indeed. And my second question is about topic toward to the future. So we know arbitration has an advantage in comparison with litigation because arbitrators are usually more commercial and also quite professional at such relevant industries. So recently, for example, we have a quite interesting concern. So when we are thinking of something quite fancy in these days, digitalization and decarbonation, and suddenly we realize that there might not be any appropriate competent arbitrators, for example, in LMCC, we don't know, also MA, and we have tried to list all of the panel arbitrators. So for the future, for example, and if like in the last week, the fintech weeks in Hong Kong, and we're talking about decarbonation, digitalization, and any ideas or suggestions like from the legal aspect, how actually you promote more arbitrators who's competent to deal with those digital and decarbonation issues. So still strengthen and make sure that the arbitration is better from view of commercial side than the litigation.
Perhaps let me try and grapple with this one, because I see this through the HKIC's Appointments Committee and also through the ICC's Nominations Commission. And actually, Cheng Yi will also have, I think, some really interesting thoughts on this from all her time with the ICC. Because a lot of what we do and what we focus on is effectively trying to grow arbitrators like plants. And you have to start them very small and very young. And so what we've spent, I think, probably the past 5 or 10 years doing is growing a great platform of female arbitrators, because we've had diversity issues in Asia. That a lot of the old arbitration practitioners were all male, especially actually in areas like shipping or construction. And the other thing we've really focused on is languages. And that, I think, is really coming to the fore. You now have this generation of arbitrators with languages who are diverse, a much more balanced platform. And now what you're seeing, I think, in the past 5 years is we're looking to look at certain industries. So you'll have seen that different bodies have got IP or tech-related panels, and then you're seeing ESG or decarbonisation. And so really what you have to do is find people who are doing it, often it's counsel, and then you start giving them their first appointments. And you effectively have to support them. And it's a really long-term investment. And it's why I keep talking about institutions, because they're the key to growing practitioners. And so you have to invest in these institutions, make sure they're really looking and focused on the arbitrators in the future, and then you find and slowly grow them. But I think if you're looking at the big picture choice between court and arbitration in a specialist area, be it pretty much any of those in Asia, decarbonization, ESG, tech, really I think arbitration is probably the only sensible choice, because you as a party normally have the option, if it's 3, to find at least one you are absolutely happy with and has that specialization and has that knowledge. And you can also give qualifications to your arbitration institution, be it HKSC, SEAC, JCA, or whatever, or the ICC. In the courts, you just turn up and you get someone. Sometimes you get someone whose main specialism is family law, and you're doing a highly complex securities dispute. You know, I think that's why arbitration is really, it has to be the only choice for these really complex, you know, sector areas. But, you know, Cheng-Yi has a kind of long background of looking at similar things through the ICC.
Thanks, Tom. Yeah, I would say arbitral institutions, especially the global ones such as the ICC and increasingly HKIC, SIC, and so on, have a major role to play in developing arbitrators with, you know, commodities expertise or whatever kind of expertise that you know, users want. And as you say, Tom, you do that by looking at the pool of arbitrators and also arbitration counsel, arbitration practitioners, and see what areas they are, you know, expert in or interested in, and then you can start them off, you know, on perhaps smaller cases or as co-arbitrators, you know, so that they start getting experience. Because it's often the chicken and egg thing. You know, a party will not appoint a young, you know, practitioner, even if he's got loads of experience in a particular area of law, because he simply hasn't got the experience as an arbitrator. And then it's down to the institutions to develop those arbitrators by appointing them. Yeah.
Sorry, can I just add a point? When I was a very young lawyer, I mean, I don't think I am anymore, but when I was a very young lawyer...
Was that last year?
You know, my thing was always, you know, I worked at federal court. I did a lot of securities disputes. My thing was corporate insolvency law. And, you know, I came to Hong Kong because I was like, this is the capital markets for Asia, and it was a rapidly growing area. And, you know, I was like, I'm a securities lawyer. And as I got older, I realized that actually a lot of the securities law disputes, you know, shares are just like goods. And a lot of the laws that apply to, you know, sale of goods actually also apply to shares, because they're kind of chattels and you can, you know, move them around. And there's a lot more similarities. And in the crypto space, I would like to say, like, you know, security tokens, I mean, they're essentially like IPOs, I mean, without the regulation. In fact, you know, with the whole FinTech week, I think the decision is to try to apply, you know, the SFO and, you know, the existing regulatory landscape to security tokens and to, you know, whatever applies in the crypto space. So I agree with you, specialism is important, but there are, I mean, I think areas of law don't, you know, function kind of out of sync with each other. I mean, that's why we have, you know, the CFA and, you know, who is obviously generalist judges at the top of their legal profession, but they see many areas of the law and, you know, there's uniformity. So yes, one of the advantages definitely is to arbitration is the commerciality of it. And I think that really largely applies to understanding how the industry works and not making legal decisions that are out of sync with what the industry wants. But then, you know, at its bottom, I do think that there are a lot of similarities in areas of laws, and you can't simply just say, well, this area means that that's certain specialty and that's got completely different from other areas. So that's my only other contribution to that.
Great, thank you. And I believe we are actually at the end of our session today. So I just want a major thank you to all of our panelists today for making the time to do this, and also for all the prep work that goes into doing this panel. your very, very busy schedules. I know all of you are extremely busy, so, it was absolutely fantastic that we were able to put this together. And thank you again to the Moot Alumni Association and to Withers Worldwide, my firm, for putting this together and sponsoring this event today. And I hope everyone found this as educational as I did. Have a good day.
And with that unsolicited praise, don't listen to her, you have a short break. We hope to welcome everyone here and hopefully more back for panel number 2, which will discuss the CISG, amongst many other things. That panel is also hybrid, and we will have 2 speakers joining us. Yes, so please come back by 3:45. Got that in 12 minutes.